seconds, 5 seconds. Start. Notably, the expressions warehouse and warehoused goods have been defined in the Customs Act in sections 243 and 244 respectively. As per the applicable provisions at the relevant time, warehouse means a public warehouse appointed under section 57 or a private warehouse licensed under section 58. Warehoused goods means goods deposited in a warehouse. As aforesaid, there is nothing to indicate that the bonded warehouse where the stated goods were kept by the appellants and eventually sold formed part of the customs port or land customs station, if so the legal fiction of sale being deemed to have taken place in the course of import of the goods into the territory of India would have no bearing and applicability to the present cases. To get over this position, emphasis was placed by the appellant on the exposition in the Indian Tourist Development Corporation, which had considered the situation where the goods were kept in the bonded warehouse and were made available in the duty-free shops for sale. This court opened that since the goods were supplied to the duty-free shops situated at the international airport, Bengaluru, for sale, it cannot be said that the said goods had crossed the customs frontier of India. We fail to understand as to how this decision will be of any avail to the appellants, for the court was not dealing with a situation as in the present cases in which the goods had crossed the customs port or land customs station area and kept in the bonded warehouse, where the sale by appropriation of the goods was effected as such. However, the petitioner repeatedly non-performed and failed to meet its own targets, causing losses to the respondent. The petitioner breached its obligations under the agreement, including but not limited to its obligations under Article 25 2A of the agreement. According to Article 25 2A, in case of underperformance of the petitioner by more than 15% from the projected gross operating profit for consecutive 3 years, the respondent has a right to terminate the agreement without any penalty. It is the case of the respondent that the petitioner has underperformed by more than 15% from the projected GOP for consecutive 3 years. That is, accordingly, the respondent exercised its rights under the agreement and issued a notice on July 28, 2020 to the petitioner seeking to terminate the agreement on expiry of 60 days. The petitioner did not respond to the notice. It did not make any attempt to amicably resolve the matter between the parties. Instead, the petitioner filed the present petition seeking protection from this court against termination of the agreement. Learned Counsel submitted that the petitioner in its petition has not disputed the underperformance on its part, as the reason for issuing the notice. According to him, on September 8, 2020, the petitioner had issued two letters through email to the respondent informing that its current journal manager has resigned with effect from September 30, 2020, which has been accepted by the petitioner.